Dear students, after studying this module, you will be able to learn about explosive substances, dowry prohibition, cosmetic drug acts, understand the importance of these statutes in India, know the procedure to deal with for these kind of cases, discuss how these laws work while maintaining a fair trial. First, Explosive Substances Act of India. An explosive is a reactive substance that contains a great amount of potential energy that can produce an explosion if released suddenly, usually accompanied by the production of light, heat, sound and pressure. The potential energy stored in an explosive material may be chemical energy such as nitroglycerin, pressurized gas such as gas cylinder or aerosol can, nuclear energy such as uranium-235 and plutonium-239. There are many types of explosives which are toxic to some extent. Manufacturing inputs can also be organic compounds or hazardous materials that require special handling due to risks. The decomposition products, residual solids or gases of some explosives can be toxic, whereas others are harmless, such as carbon dioxide and water. Examples of harmful byproducts are heavy metals such as lead, mercury and barium for primers observed in high volume firing ranges, nitric oxides from TNT, perchlorates when used in large quantities. The Explosive Substances Act. In this act, the expression explosive substance shall be deemed to include any materials for making any explosive substance, also any apparatus, machine, implement or material used or intended to be used or adapted for causing or aiding in causing any explosion in or with any explosive substance, also any part of any such apparatus, machine or implement. Any person who unlawfully and maliciously causes by any explosive substance an explosion of a nature likely to endanger life or to cause serious injury to property shall, whether any injury to person or property has been actually caused or not, be punished with transportation for life or any shorter terms, to which fine may be added. Under this act, the special category explosive substance includes RDX, that is research development explosive, PETN, pentyretritol, tetranitrate, HMX, high melting explosive, TNT, trinitrotoluene, low temperature plastic explosive, LTPE, composition exploding CE, 2,4,6-phenyl methyl-nitramine or tetryl, octyl, mixture of high melting explosive and trinitrotoluene, plastic explosive Kirki, PEK1 and RDX or TNT compounds and other similar types of explosives and a combination thereof, and remote control devices causing explosion and any other substance and a combination thereof with the central government may by notification in the official gazette specify for the purpose of this act. Punishments under Explosive Substances Act. Punishment for causing explosion likely to endanger life or property have been stated under the malicious and unlawful usage of explosive substances as indicated below. Any person who unlawfully and maliciously causes by any explosive substance an explosion of a nature likely to endanger life or to cause serious injury to property shall, whether any injury to person or property has been actually caused or not, be punished with imprisonment for life or with rigorous imprisonment of either description, which shall not be less than 10 years and shall also be liable to fine. Any special category or explosive substance, an explosion of a nature likely to endanger life or to cause serious injury to property shall, whether any injury to person or property has been actually caused or not, be punished with death or rigorous imprisonment for life and shall also be liable to fine. Any person who does any act with intent to cause by an explosive substance or special category explosive substance or conspires to cause by an explosive substance or special category explosive substance an explosion of a nature likely to endanger life or to cause serious injury to the property, or any person who makes or has in his possession or under his control any explosive substance or special category explosive substance with intent by means thereof to endanger life or cause serious injury to property or to enable any other person by means thereof to endanger life or cause serious injury to property in India shall, whether any explosion does or does not take place and whether any injury to person or property has been actually caused or not, be punished. In the case of any explosive substance with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. In the case of any special category explosive substance with rigorous imprisonment for life or with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. Any person who makes or knowingly has in his possession or under his control any explosive substance or special category explosive substance under such circumstances as to give rise to a reasonable suspicion that he is not making it or does not have it in his possession or under his control for a lawful object, shall, unless he can show that he made it or had it in his possession or under his control for a lawful object, be punished. Punishment of abettors. Any person who by the supply of or solicitation for money, the providing of premises, the supply of materials or in any manner whatsoever procures, counsels, aids, abets or is accessory to the commission of any offence under this article shall be punished with the punishment provided for the offence. Restriction on trial of offences. No court shall proceed to the trial of any person for an offence against this Act except with the consent of the District Magistrate Act be with the offence. Next is Drugs and Cosmetic Act of India. Cosmetic, any article intended to be rubbed, poured, sprinkled or sprayed on or introduced into or otherwise applied to the human body or any part thereof for cleansing, beautifying, promoting attractiveness or altering the appearance, and includes any article that intended for use as a component of cosmetic. Manufacture. In relation to any drug or cosmetic, it includes any process or part of a process for making, altering, ornamenting, finishing, packing, labeling, breaking up or otherwise treating or adopting any drug or cosmetic with a view to its sale or distribution, but does not include the compounding or dispensing of any drug or the packing of any drug or cosmetic in the ordinary course of retail business. Patent or proprietary medicine, a drug which is a remedy or prescription presented in a form ready for internal or external administration of human beings or animals, and which is not included in the edition of the Indian Pharmacopoeia for the time being or any other pharmacopoeia authorized in this behalf by the central government. Drugs Technical Advisory Board or DTAB, ex officio, Director General of Health Services, Chairman, Drugs Controller India, Director of the Central Drugs Laboratory, Calcutta, Director of the Central Research Institute, Kasauli, Director of Indian Veterinary Research Institute, Izzatnagar, President of Medical Council of India, President of the Pharmacy Council of India, Director of Central Drug Research Institute, Lucknow. I repeat, all these together make the advisory board for the drugs. Next is Dowry Prohibition Act of India 1961. A dowry is a transfer of parental property at the marriage of a daughter. Today, dowry has become a widespread evil and social menace and biggest problem faced by women. Marriage is becoming a big source of exploitation and of getting rich overnight in some communities. The spread of education has not helped in curbing the social evil of dowry. The more educated is the young man, higher are the demands for the dowry. The dowry system is one of the primary cause of female infanticide and feticide in India. Domestic violence is another consequence of this evil. Indian Parliament enacted the Dowry Prohibition Act in 1961 to minimize the evil effects of dowry. The object of Act is to prohibit the giving and taking of dowry. According to Section 2, Dowry Prohibition Act of 1961, dowry means any property or valuable security given or agreed to be given either directly or indirectly, A, by one party to a marriage to the other party to the marriage, or B, by the parents of either party to a marriage or by any other person at or before or any time after the marriage in connection with the marriage of said parties, but does not include dower or meher in the case of persons to whom the Muslim personal law Shariat applies. Taking or giving of dowry or abetting to give dowry or abetting to take dowry continue to be offences. Demanding of dowry by any person directly or indirectly from parents or guardian of bride or bridegroom is also a dowry offence under Dowry Prohibition Act 1961. A maximum and minimum punishments has been laid down. It is a unique law which considers the person who commits the act as well as the person against whom the act committed as offenders. If the dowry has actually been received but its receiver is not the bride, then the act lays down that the dowry has to be transferred to the bride. The failure to transfer the dowry to the bride within the stipulated period constitutes a dowry offence, for which the offender is liable to be awarded the same punishment as the taker of dowry. If the bride dies before the transfer of dowry is effected, her offsprings will be entitled to it. Section 4 of the Act states penalty for demanding dowry. If any person demands directly or indirectly from the parents or other relatives or guardian of a bride or bridegroom, as the case may be, any dowry, he shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years, and with fine which may extend to 10,000 rupees. Provided that the court may, for an adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment for a term of less than 6 months. Section 3 of the Act penalizes both the giver and the receiver. Penalty for giving or taking dowry. If any person after the commencement of this Act gives or takes or abets the giving or taking of dowry, he shall be punishable with imprisonment for a term which shall not be less than 5 years, and with fine which shall not be less than 15,000 rupees or the amount of the value of such dowry, whichever is more, provided that the court may, for an adequate and special reasons to be recorded in the judgment, impose a sentence of imprisonment of a term of less than 5 years. Next is Protection of Women from Domestic Violence Act 2005, an act to provide for more effective protection of the rights of women guaranteed under the Constitution who are victims of violence of any kind occurring within the family and for matters connected therewith or incidental thereto. Under Section 3 of Protection of Women from Domestic Violence Act 2005, definition of domestic violence in subsection B, harassment or any injuries for dowry shall constitute domestic violence. More than 5,000 women are killed annually by their husbands and in-laws who burn them in accidental kitchen fires if their ongoing demands for dowry before and after marriage are not met. Many cases go unreported. Despite protest by women's organizations, serious activism, legal amendments, special police cells for women, media support and heightened awareness of dowry being a crime, the practice continues unabated on a massive scale. Despite every stigma, dowry continues to be the signature of marriage. Dowry is a complicated phenomena in the Indian society and it cannot be eradicated by simple legislative measures. It is an accepted fact dowry is not an easy problem to be eliminated. However, such a social menace can be combated with effective strategic measures that would protect the dowry of the Indian bride and would allow such dowry to be treated as her exclusive property. Deaths due to dowry. Dowry death has been defined under section 304B of Indian Penal Code as when the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassments by her husband or by any relative of her husband for or in connection with any demand for dowry, such deaths shall be called dowry death, and such husband or relative shall be deemed to have caused her death. Whoever, being the husband or the relative of the husband of a woman, subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. Any willful conduct which is of a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of the woman or harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demands. Now we will deal with a case study. Mahbuba Khanum of district Bhola is now fighting with death in the burn unit of DMCH. Her guilt is she did not pay the promised dowry to her husband from her parents' home, and at the same time she did not accept the extramarital relation of her husband and protested it. For these two faults her husband set fire on her body in daylight. This caused severe burn in Mahbuba's upper portion of body and her 2 hands, nose and neck. Mahbuba is the daughter of Aminul Islam of Vola Upzila. She was married with Anwar Hussain, son of Faizullah Mia of the same area. Her in-laws family was pushing her for dowry from the day of her marriage. She was both physically and mentally tortured by her in-laws family members. She was bitten by stick and on leg on daily basis. They would put salt in her body after she was bitten. She told her helplessness when she was interviewed in the burn unit of DMCH. At the same time, she expected the right punishment for her husband. For this attempt of Mahbuba, her in-laws family is threatening her and they said they will kill her 4-year-old son. Mahbuba told that she got good behavior for only a few months from her in-laws family when she married without the consent of her parents. After that, she was tortured for dowry regularly. She could not do any job in spite being educated. Only a few days ago, she got a job in school after a fighting with her husband. But as she became mother of her child, so she accepted all the brutality of her in-laws family for the sake of self and her child. At last, 23rd November, when she was quarreling with her husband for dowry and his extramarital relation, her husband suddenly beated her. At the next morning, her husband again started quarrel with her in front of Fahmid Enterprise, which is actually a shop of petrol and mobile phone near the North Bus Stand on her way to school. Mahbuba said this shop is too made by her money. While the quarrel was on, suddenly her husband said, "Wait, let me teach you," and then he took some petrol from the nearby can of petrol and poured on Mahbuba's body and set her on fire. The incident took place at 9 a.m. There was nobody on the shop. When she was caught by fire, she came out to the street and local people took and admitted her to the local hospital. Late, she was transferred to DMCH. She complained against her husband at last on 27th November. According to the complaint, her husband is now in the jail. Mahbuba's family informed us that from her admission in the burn unit, 2 operations were performed. She needed 2 more operations in her chest and neck. These will cost more than 90,000 taka and she needs more. But who and how will the money be paid is still unknown. Now we will conclude with the summary. After reading this module, you shall be able to understand and learn about various important acts of India which help in a lot of ways. Example, Dowry Protection Act helps women avoid dowry deaths, etc. Further, you have learnt about Explosive Act and Cosmetic Acts of India.